Hi, everyone. Welcome to the webinar today. My name is Alexandra Alvarado, and I'm the Director of Marketing and Education here at the American Apartment Owners Association. Today, we have with us Justin and Robert Friedman, two attorneys in New York that have helped us throughout the years to stay up to date on what is happening with New York laws. And it seems like we were just talking about this before we got on this webinar. It seems like things just keep changing and changing. And so we constantly have to keep up to date. We're going to go over specifically some eviction, rent increase laws, lots and lots of different things. And as you all are starting to come into the webinar, I would love it if you could put in the chat where your rental properties are located, what cities, so that we can adjust this presentation if we need to certain areas. So if you can see there in the chat down below, you can put in where you are coming from. So I'm going to put mine. I'm in Los Angeles, so I'll probably be the only Californian here, but go ahead and put it in there, and Justin and Robert will take a look there at the chat. So I see Westchester, Rochester, Brooklyn, Ithaca, New York City, Central Texas. Okay. Well, we might not have much for Texas, but we definitely have New York coming on. So if you have some New York maybe plans to invest in there, this would be great for you. We're not going to cover California laws today. This will be just New York. We're just looking at specifically New York in general, but also some cities in New York that have had some recent updates. We'll be covering some of those. So I'll let you guys keep going on there. If you are in California, we will be having another webinar in a few weeks that will be California specific, but we'll leave it at that. Also, a good idea if you're ever looking at investing in New York. So I want to talk a little bit about our speakers to get this show on the road. So we have with us Robert or Bob Friedman, who has been in the legal business here for 45 years. That is a ton of experience. He's seen it all in New York. He's written books, blogs, newspaper columns, presented seminars and webinars like this one, so many of them, and mentored law school students. And he focuses on how to avoid probate, asset protection and preservation, estate planning, and of course, how to survive legally as a landlord. That is also the title of one of his best legal guides. They have a ton of resources on their website, so I will definitely be sharing with you their website and all of the nice resources they put out. Justin earned his JD from the Catholic University Columbus School of Law in 2017. He received a BA from SUNY Geneseo in 2001. He's done extensive work in the fields of education and content writing, and he's honed his skills from his previous career now to serve his clients in New York. And he's a team leader of the litigation department, and he advises landlords on evictions on a daily basis. So they see a lot of eviction cases and obviously have a ton of experience. So this is the right crew of attorneys to ask your questions to. So with all of that said, we're going to go through this presentation roughly an hour. We'll have some Q&A. Stick around if you have questions. Please put them in the Q&A box, not the chat. That'll be most helpful for us to keep track of everything and all the questions coming through. Of course, I will send you the recording tomorrow, so don't worry if you have to jet out early for some reason. I will send you the recording. And of course, like I mentioned, Robert and Justin's information and their website. So if you need anything, you can follow up with them. And also the PowerPoint slides, which I know you all will find pretty helpful to review. We're going to go over a lot. So with all that said, thank you for coming on. And I appreciate Justin and Bob, you being here. It's always a pleasure. I'll let you all take it away.
Thank you very much. First of all, just the usual disclaimer that this is an informational presentation, a lot of ground to cover and not in the detail that we really need to for this to be considered legal advice. So this is not legal advice. This is an informational presentation, especially on a subject such as landlord-tenant law and the new good cause eviction law, which is going to differ depending on which municipality you're in, how that's applied. So we're in Western New York. We're familiar with the laws in Erie County, Niagara County, Genesee County, Monroe County, Orleans County. So if you'd like to call us to, discuss your particular situation, we can advise you on that. I notice there's a lot of people from New York City at the presentation today. We will be discussing in sort of broad strokes how the new good cause eviction law applies in New York City. But again, you're going to want to speak to a local attorney if you're having any sort of issues. If you're in Western New York, feel free to give us a call. So, as you're aware, we like to do this every twice a year or so to update everybody on the new laws in New York as far as landlord tenant law goes. This has been a huge year as far as a sea change in landlord tenant law with the good cause eviction law, which will be the main focus of the presentation today. But we still like to go back to 2019 at all of these presentations, just as a reminder that the Tenant Protection Act of 2019 is still in effect, and the changes that statute made to the landlord-tenant law, those are still in effect. So we're not going to go over the whole thing, but I just want to highlight a couple areas where we still see our clients not following the law. Okay, so first and foremost, as of 2019, in addition to the 14-day pay or quit letter, we're probably all aware that 5-day rent delinquency letters for non-payment proceedings, those need to be sent out 5 days after rent is due. So if your rent is due the first of the month, before you can start a proceeding in order to make a money demand, you have to send a letter certified outlining the amounts owed. Used to be the courts didn't really care about that where we practice. If you wanted to go after a tenant for a money judgment, that was required, but it wasn't necessarily a stumbling block to evicting the tenant if you didn't provide that. And we're finding in Erie County now that it is, the courts are requiring that 5-day letter and proof of the certified mailing to be included as an exhibit to the petition that's filed. So I can say in Erie County, that's an absolute requirement, and we're doing that in all the other counties that we practice in as well. So it's something that you may want to look into the courts to see if they're requiring the 5-day letter be included in the petition. On the subject of non-payment evictions, only rent can be demanded in those petitions. We've seen petitions challenged where utilities or a late fee is demanded. It's been challenged as a demand for a legal amount of money, since the statute now says that non-payment can be commenced for rent only. And a security deposit can only be as much as 1 month's rent. Cannot be any more than 1 month's rent. Can't ask for first and last anymore. And at the end of the tenancy, when the tenant moves out, you must return that within 14 days. And if there are any deductions, you itemize those deductions. Or if there's no amount to be returned, it's very important that you send a letter, again, itemizing why it has not been returned and being as specific as possible as to why those amounts were deducted. And you're required to send that via certified mail. In best practice, we send that regular mail as well, because not everyone signs for certified. If we have an email address, we send it that way too, just so that there can be no question that that has been provided to the tenant, because the tenant's recourse, if they do not receive their security deposit back or an itemization of the deductions, they could be entitled to damages in the amount of the security deposit times 2. So it's very important that you send those letters out well within 14 days of the tenant vacating the apartment. Late fees can only be demanded after the 5th of the month, and they can only be 5% of the rent, or $50 if 5% of the rent would be more than $50. It's capped at $50 for late fees. And then briefly, the 30, 60, 90 rule. So those numbers indicate how much notice you have to give a tenant for any manner of notice, depending on how long they've been there. So if the tenant has been there for less than a year, to terminate their tenancy or not renew their tenancy, you have to provide 30 days notice. If they've been there more than a year or more than a year but less than 2 years, then it's 60 days, and over 2 years, you have to provide 90 days. So that's not only for terminating tenancy or non-renewals, but for increasing the rent more than 5%, or making any substantial changes to the lease, they need to be provided with that much notice. The New York Court's website is now has a bunch of forms that they're providing for all of these notices that we were talking about, including the 5-day notice of delinquency of rent, all 14 day notices, notices of termination, holdover petitions. There's a website where you can find all these. I wouldn't necessarily recommend using them all because I think the person who put them together might not be completely up on the law because I find them insufficient. However, you are required to use their notices of petition. This has been a point of confusion even amongst attorneys and judges where we practice as to which of these forms are required. And I'll go to the website so you can see where all the forms are. So here you have the 5-day notice of past due rent, and they come in a PDF where you can fill in by hand or a fillable one. So, again, as a practical point, I've used the fillable PDFs, and sometimes, although it appears on the screen that you're getting all of the text on there, when you print it out, there's a substantial portions missing. So I would recommend using the plain PDF rather than the fillable PDF. Okay, and so here's the written demand for past due rent. That's the 14-day notice. And then here are the notices for non-payment, which you are required to use these forms. And there's a special form for New York City. Again, I don't use that form. So the differences, I'm not quite sure what the differences are. And then outside of New York City, here's the petition for non-payment for outside of New York City. And they have all of the information that you need there. For some reason, they're asking for the landlord's phone number on there. A lot of landlords don't want to give their phone number to all their tenants. It's not required per statute that you put the phone number on there. Oftentimes, I ask my clients, "Is it okay to put the phone number on there?" They say no. Then I just put my phone number on there. I've never run into any issue with that. One thing you'll notice on this non-payment petition that is not included, that we include in all of our non-payment petitions, is the Federal Debt Collection Practices Act disclosure, disclosing that you're a debt collector. If an attorney's doing this, that's not on there, and that's required to be there. So we include a separate sheet with that FDCPA language. Just another sort of practical point, doesn't really have anything to do with the law, but just little things that you could get tripped up on. As you see that this part down here is shaded. If you print that out and then scan it in, send it to your process server, that's just going to show up as a very dark box that tenants can't see. And I've seen tenant defense attorneys raise that as an affirmative defense, as that to the client doesn't speak English, and they didn't see this information as to who they could call to get an interpreter. Same with this down here. It almost seems that these state forms that are so insufficient were designed with these stumbling blocks. And that's put my tin hat on, but that's ultimately the result. Is you have to be very careful with these state forms that are required. Okay, so we're back here. And so there's also a whole, I'm going to go back to this screen here. So if you wanted a holdover eviction, there's a separate section down here. So here is the notice of termination that the state is recommending that you use. We use our own. And then here are the notice of petition for New York City that you are required to use. And here is the notice of petition for outside of New York City that you're required to use. Okay, again, the actual petition itself, that is not required, and we find that those are insufficient, so we don't use those. We use our own forms that we've developed over the years that include all of the correct information. Again, these forms are insufficient. I'm not quite sure why the state is recommending these or requiring some of them in some cases. Hey, finally, another required form Again, I was saying only the notices are required, but I glossed over the 231C notice that is now required. You have to serve that with all petitions, all notices, anything related to eviction. We'll talk about that in a little bit more detail later. The 231C notice is, of course, the notice of applicability or inapplicability of the good cause eviction law. So I would recommend using the form that is provided on this site. It looks like this. There are other versions of the form, but they don't have spaces for the put the landlord and tenant's name in, and then at the end, the landlord or attorney or agent is supposed to sign off on it. Okay, so this is a 6-page document that you now need to serve with all of your eviction related materials, all new leases, all renewal leases, all rent increases. Okay, so here you just have the information about the property, and then we'll get into this a little bit more later. I'm going to put this over to the side for a second, okay? We talk a little bit more about good cause eviction and where it applies, where it doesn't apply, what's exempt, and so on. Okay, so this was enacted a little less than a year ago, April 20th of 2024. Generally speaking, limits what properties and what tenants are subject to eviction, caps rent increases, and it requires lease renewals. So no longer can you just opt to not renew someone's lease without cause. You have to have a cause now if you're in a qualifying property. Currently, this is affected in all parts of New York City, mostly downstate and central New York, Kingston, Ithaca, Poughkeepsie, Beacon, Newburgh, Nyack, Hudson, New Paltz, Catskill, and just recently, as of December of this year, the first upstate, or maybe Rochester would argue that they're not upstate, but regardless, anywhere close to where we practice, only major city outside of New York City in this area, Rochester, recently adopted this. And since I put this together, Croton on Hudson, which is different than Hudson, they've enacted the New York good cause eviction law as well. Other municipalities can opt into it. I know it's currently being discussed in Buffalo. Nobody really has any sense as to when it would pass. I think it was quite a surprise when it passed in Rochester. It was being discussed, but I don't believe the lawyers that I spoke to and even some of the judges didn't expect it to be pushed through so quickly. Okay, so this is generally bad news for landlords if you just take it at face value. When I'm saying this, you can't evict people without good cause, but there is good news that there are a number of exceptions. Okay, so we just go through them here. Okay, so if you are a small landlord, you are not subject to the good cause eviction law. Now, small landlord, the definition of small, that's up to the jurisdiction to decide what is small. And every jurisdiction other than New York City says you are a small landlord if you own one rental unit. If you own any more than one rental unit, you are no longer a small landlord. So it's a very narrow definition in all of the jurisdictions that we discussed other than New York City. In New York City, it's over 10. You can own up to 10 units and you're still considered a small landlord. Now, if you're an owner who lives in a unit that has less than 10 units, then the exception will apply to you, regardless of whether or not you're considered a small landlord. As long as you live in that building and there are less than 10 units in that building, you are exempt from GSEL. Also, any condos or co-ops, GSEL does not apply. Manufactured homes, or mobile homes, as they're also known. Those GSEL does not apply to those. If there's an employee living in a building, for example, you have a superintendent who, some sort of building manager, someone who works for you who's living in the building, this law will not apply to them. Any sort of affordable housing receives any affordable any sort of federal subsidy, any sort of subsidy at all. Or if the unit is subject to rent regulation, those sort of properties, the law will not apply. Also, any new builds So the certificate of occupancy was issued after 2009. Those new buildings don't fall under this law. Additionally, even if it's a building that was built prior to 2009, but has a new certificate of occupancy that was issued after this time, then it will not apply. Okay. And sort of hospitals or assisted living, um, hotels, motels, and dorms. We run into a lot of motel owners who have motel guests who don't leave and need to be evicted. They will not be subject. They will not be able to avail themselves of this law. Any properties that are used by a religious institution, and then finally another exception that will differ depending on which jurisdiction you are in is that if the percentage, if the monthly rent is a certain amount over the percentage of the fair market rent, luxury apartment, then it would not apply. So in New York, that's going to be if it's over 245% of the fair market rent. That also applies to Rochester. Pretty much everywhere else, it's going to be 345% over the fair market rent in that particular jurisdiction. Okay, so you can find that information at this website here as to what the fair market rent is in your area by county, okay, and by bedroom. It'll show you what fair market rent is, and I believe they update this every a couple times every year. So there's that link up there. It's in the PowerPoint, which we'll send to you, so you can link to this through the PowerPoint. Okay, so now if you don't fall under one of these exceptions, you still can fall back on good cause. It's called the good cause eviction law. So if you have good cause, you'll still be able to remove your tenants. It's just going to add probably an extra step in the whole process because you're going to if it comes to it, if you don't settle the case, have to establish before a judge that that there is good cause based on one of these reasons. Okay, so as always, non-payment of rent. You still just have to serve the 14-day notice. And if they don't pay, you can move forward with the eviction. That'll probably be the easiest exception here. If you have a good lease that has rules that you want to make sure you're able to enforce, if the tenant violates the lease, that could be good cause for termination of tenancy as well. Even if you don't have a very detailed lease, if you can establish that the tenants are doing something to cause a nuisance or permit a nuisance, and you can establish that, you could have a tenant removed for nuisance behavior, for damaging the premises. Again, these are all things that you should have in the lease, so you don't have to fall back on these specifics. But if you don't have in your lease that you can't cause damage to property or damage to property, well, the new law says that that's good cause to remove someone. Same with interfering with another tenant on the premises or in the building or the owner's use of the premises. Illegal use of the premises, if there's illegal drug activity going on there, prostitution, that is good cause as well. There's actually part of the real property law says that you don't even have to serve notice on a tenant if you want to remove them for illegal use. If you can establish that the property is being used for illegal purposes and you have police reports, you can move straight to the petition phase without providing notice. If the tenant is refusing you access to make repairs or improvements, that will be considered good cause under the good cause eviction law. Or the landlord can establish that the property needs to be demolished. If the landlord wants to withdraw the property from the rental market for a good cause, or if the tenant is refusing reasonable changes to a lease renewal, all of these could be brought before the court to make the case that good cause exists. Okay, so even though we discussed all of these exemptions, just because your property may be exempt for any of those reasons that we discussed, or for the reason that good cause eviction simply hasn't been enacted in your particular jurisdiction yet, as in Buffalo, you still need to include the 231C notice explaining to the tenant why or why not the good cause of eviction law does not apply. So we, even though there is no good cause eviction law in Buffalo yet, we include that 231C notice on every single 14-day notice that we send out, every notice of termination, every non-renewal, every notice of rent increase, and then include it again with the actual eviction petition. The tricky part here is that it also needs to be included with every lease and every time you renew someone's lease. So if you are, provided someone a lease after this law went into effect and you did not include the 231C notice, in practice, or in theory, I'm not sure how this is going to play out in practice. In theory, you will never be able to evict that tenant if you didn't provide them with a 231C notice. I've gone to court very shortly after this law was enacted, and some attorneys didn't include this, with their petition. The tenant didn't even show up, and the judge just dismissed it without even any argument being made. So there's been an indication that if an eviction is brought under a lease that does not include this notice, that the petition will be dismissed. So if you're in that boat where you gave someone a lease recently, after August 18th, 2024, because that's when it went into effect, you're going to want to provide them some sort of lease rider, some sort of addendum to the lease, and have them sign off that they received it as a supplement to the lease if you hadn't included this notice. Okay, so I have a link to the notice here. So now we look through it. Oh, I have to go back and get it through the other link. Sorry about that. I was going backwards now. Okay, so here it is. So everyone have a look at it if you haven't got eyes on this thing already. Okay, so this is not constructed that well. There's some things about this that really don't make a lot of sense. So I'm not going to go through every part of it, but first of all, you put the information here about the property, and then answer the simple question: is it subject to G cells or subject to the good cause eviction law? And here in Buffalo and other jurisdictions that haven't enacted it, we say no, and then it says why not, and we say it hasn't been enacted here, and we're done. It does say please mark all applicable exceptions, but we've received the instruction that if it hasn't been from the local courts, if it hasn't been enacted, all you need to do is say it hasn't been enacted, and essentially you're done, other than signing the end. Okay. If there's another exception, for example, if you're in Rochester where it hasn't been enacted, you would say you could still say no, because maybe you fit one of these exceptions: the small landlord exception, the owner occupied exception, the rent regulated, subsidized manufactured home. Any of the exceptions, you'd still say no, but you would check all of the boxes that apply. So all of these correspond to that list that I put up earlier for the exceptions. Okay, if it does apply, you would say yes, and then skip to this part 4. Now, I mean, you're providing this for many other reasons than not renewing a lease, but this is the language here. So maybe it's because you're informing them that you're terminating their tenancy. It doesn't have anything to do with not renewing lease, or you're informing them that they owe rent. This is where you go to, and then all of those good causes are listed here: recovering possession for own personal use. There's an employee that lives there, and here's where you check the landlord is not renewing the lease because the tenant has failed to pay rent. So that's what you check there. Again, the wording is just that doesn't really make any sense. You're not renewing the lease. You're providing a 14-day notice. But again, this is the box that would be checked. If you are providing this 231C notice with a lease, a new lease or a renewal lease, then you would just check B. All right. So you're just getting this because the law requires me to give it to you. I'm not, trying to terminate your tenancy, but I'm required to give it to you. You just check that box there. Okay. And then there is a separate section if you are raising the rent, then you would go to 3 here and explain why you're increasing the rent. Okay, again, I just can't stress enough that you're required to serve that notice, even if the good cause eviction doesn't apply in your particular jurisdiction. Okay, there are some notices that I haven't listed there, such as you can terminate a license of someone who's not a tenant, who's living on your property, with your permission and doesn't pay rent and isn't a tenant. The statute doesn't specifically say you have to provide the 231C notice with a 10-day notice of licensee termination, but I'm just erring on the side of caution. I don't think it could hurt to include it with a notice such as that. And here's what we discussed before. Again, where you haven't adopted G-Cell, these are the boxes that you check on that form. Again, so like I was saying, if that notice isn't included, I can't speak for every single court, but every court I've been in is dismissing these petitions that don't include the 231C notice, whether or not the tenant even shows up. Again, if you have a month-to-month agreement with someone right now, that is considered a renewal lease. Every time that month changes over and you're in a new month, it's month to month, that's considered a renewal lease. So get these forms out to your tenants and have them sign some sort of acknowledgement of receipt. So in the event that you ever need to remove these tenants, even if you're not having problems with them now, they should be provided this notice. So in the event that it comes down to evicting them, you can show that they were provided with the notice pursuant to the statute. Okay, I didn't notice that there was anyone who's in Erie County in the chat. I usually like to go over the very unique way they have going about things in Erie County, where all evictions are held in a county regulated court. The towns and villages do not hear evictions. I'm not sure if it's like that in any other jurisdiction. I know it's not in the other counties we practice in. It's not in Monroe County. I saw a lot of people from Rochester there. So I don't need to go over the HUD court material with you, but I would like to note that I've seen some similarities as to how default evictions are dealt with from court to court, even not in Erie County. When a tenant doesn't show up the first appearance or even a second appearance, and the court grants a warrant on default, and you go buy the warrant and engage the marshal or sheriff to execute and serve that warrant. Oftentimes there's a pretty big gap between the day the warrant is issued and the day the tenant is forced to vacate. By statute, the marshal or law enforcement agent has to wait 14 days between serving the warrant and then going to the property to compel the tenant to leave. In Buffalo, that's more like a month because we're so bogged down that they can't get around to executing the warrant 14 days after it's served. So usually there's a period of about 30 days before the tenant can be removed. And they're put on notice that, you're being evicted. And if they are being evicted based on their non-appearance and they have a good excuse for not showing up, or even if they don't have a good excuse, they have to fill out some relatively simple paperwork to stay that warrant and bring the matter back before the court. So I just want to make everyone aware of that because that's what I tell all my clients. Don't celebrate just yet if we get a warrant granted on default, because as soon as that warrant is served, the tenant is going to have an opportunity to bring it back before the court, which could potentially delay things longer than had the tenant just shown up and stipulated to a particular out date. So again, this is specific to evictions in the jurisdictions where I practice. I have to imagine in New York City, where a lot of you are tuning in from, just based on the population, that maybe you're all waiting even longer. But the first thing clients often ask me is, how long is this going to take? And they oftentimes express frustration, even after I explain to them that it's not like the days of old where you can be in and out. Of course, pursuant to the Tenant Protection Act of 2019, a tenant is entitled, no matter where you are in the state, to at least one adjournment of 2 weeks. So if the tenant shows up, I mean, I wouldn't be expecting to, have anything resolved at the first appearance unless they, say, hey, I'm already on my way out. Well, let's just stipulate to an out date. Even though it's only a 2 week adjournment that they're entitled to, again, just given the logistics and the backup in a lot of these city courts, we're looking at 21, 28 days sometimes before we're at the second appearance. And unless you request a second appearance, at least in Erie County, unless you request that it move right to a hearing, they're going to schedule that for a second conference to try to resolve it. And if you can at that point, then they'll schedule it for a hearing. Again, this might be something that's specific to Erie County. I have encountered this in the city of Rochester as well, that it's not set down for a hearing immediately unless requested. And sometimes that request is denied. They want to give the tenant an opportunity to go hire or not hire, have counsel appointed if they qualify, and then give tenants counsel and landlord counsel an opportunity to settle the matter before setting it down for a hearing. So again, I'd imagine that is the case in jurisdictions where there's a lot of heavy traffic. Is they're not putting these down for a hearing right after the first appearance. They're trying to settle these with a second alternative dispute resolution program. Okay, and again, the hearing, once it's requested after the second appearance, you're looking anywhere from a week to 2 weeks out. We talked already about how long it can take to execute a warrant. So, from beginning to end, I'm just talking, not including the period you got to wait while you're waiting for the notice period to run up. You're looking at, potentially 2 months from your first court date to, when the tenant is finally out of there. Don't forget, you also have to store the tenant's property. If they get kicked out on the 23rd, January 23rd, you can't dispose of their property until at least February 23rd. It's not a bright line rule. It says a reasonable amount of time you have to store the tenant's property from the time they vacate. Most corporates have interpreted that to mean 30 days. Now, what we're running into now with the weather that we're having is tenants having a very hard time getting the property out in 30 days. Can they have an extension? I usually advise my clients to grant the extension because reasonable in this sort of weather might be more than 30 days. And it's better to give them a little bit more time than be on the hook for property damage if you throw it up. Okay, that's all I have for now. I'm sorry if I sped through that, but left some time for questions. My email's right there if you want to email me any questions or give us a call. But if we have any questions that were popped up during that presentation, I'm happy to answer them now. I wasn't looking at the
Yes, we did get a few. I think one that I got multiple times was just to clarify that the 10 property max to be considered a small landlord, that's only for New York City, right?
New York City is the only jurisdiction that's adopted it where you can have that many properties and still be considered a small landlord. Everywhere else, it's one property or one unit.
So all of you on the call, basically, for most of these cities are going to be not small landlords, right?
Except, well, I did see a number of
Yeah.
people from New York City where they can have up to 10 units.
Hmm.
Uh, so I
Um,
don't. I mean, I have plenty of clients who they just have one. So
yeah, on that note, Alex in the Q&A was also asking, would a duplex house with two separate leases count as two units? What if the whole property had just one lease for the entire property?
well, I think if there's two units, if there's two units but one lease for the whole property.
Yes, I imagine maybe a family or something could be possible. I guess what he's trying to ask is whether or not the number of leases matters or if it's just that there's two
Well,
units.
the way the statute is worded is units. So I would
Hmm.
try to find another exception. I have a case just took on where it's a duplex and the owner lives on one side and he rents it out the other side. He said, well, is that considered two units? Because I'm not renting out the one unit. I live there. I mean, it could potentially be considered a rental unit though, but you fall under the owner occupied exception. So let's just go with that.
Hmm.
So in that case, I would see if another exception applies, or or check the box and then see how it pans out. It's not like you're going to be liable for any. This is confusing to everybody. Everyone's still waiting to see how these things play out, how it's
Mhm.
interpreted by different judges. You're not going to be liable for some sort of misrepresentation of a material fact for putting that down when this is so confusing to the layman. Um,
Yeah.
I,
Yeah.
if there's one lease, I would save that for a hearing and argue that because
Yeah, Frederick,
certainly tenants attorneys are going to be arguing every single one of these exceptions
of course.
or arguing whether or not good cause applies. So I would leave that to the interpretation of the judge. Like I said, the way that this document is worded, it's very confusing, especially when you get to the exceptions portion of it.
Yeah, and I think Frederick here had a good question too. You kind of briefly spoke on what happens if the notice incorrectly states that the property is or is not covered by GCEL. So you're kind of saying that it's sort of, I guess, are you better off just saying that you are covered by it
Well, I,
if you're
I would
not
I would
sure?
say if it's I wouldn't willingly misrepresent
Mhm.
a fact like that. Now you're talking about a duplex where it's just one lease covers the whole thing, and there's one family living there. I think there's an argument to be made there. I think that that's open to interpretation.
Mm.
So I think there are cases where it's not open to interpretation. I wouldn't materially misrepresent anything. But I
Mm.
think where an argument can be made, especially since the law is so new and there hasn't been any case law made on it, in that situation I would feel comfortable saying like this is only one unit because it's one lease and one family lives there. If that's indeed the case.
Yes. Okay, that makes sense. Jerome was asking also if I have multifamily homes in and out of New York City, do the units in another city count?
I don't
Or
I don't
is
believe so. I think when you're talking New York, if you have less than 10 in New York, then that's what they're talking about.
oh, okay, so it's in the entire state. So if I had less than 10 units in New York City, but I also have units outside of New York City, then in that case, according to New York City law, would I be a small landlord?
I just pulled up the 231C notice again to look at the actual language. So
It says located in New York City, or
for small landlords located in New York City, yeah, I would say that this is jurisdiction dependent because if you're in another jurisdiction where it's only one, and then you own some in. I would. Is Jerome in New York City
I'm
or
assuming
another?
so, but he didn't say specifically.
Again, I think this is one of the provisions that could be open to interpretation.
Hmm.
It doesn't say it says for small landlords located in New York City. It doesn't say where the units need to be located there. It potentially an argument could be made on both sides of it. And that's another
Yeah.
case where the statute isn't entirely clear.
Yeah, and I think that's something that I'm seeing as sort of a general theme is that it's not super clear in some cases, and even attorneys are probably interpreting it differently, and so we'll just have to see how it plays out in the courts in some of these cases because it's so new. So a couple more questions came in about that 231C form. One is that does the tenant need to acknowledge it? And someone else asked, what if they refuse to sign and acknowledge it?
So, I was suggesting as a best practice to cover all your bases, try to get the tenant to sign an acknowledgement that they received it. Of course, there's going to be difficult tenants who aren't going to sign it. And if you can just document that it was provided, I would hope that that would cover you in a case where you eventually had to evict the tenant who refused to sign the 231C sign acknowledgement that they
Yeah.
received it. And if you
So,
just again, like with those returning the security deposits, send it regular mail, send it certified, keep the receipt, send them an email if you have an email address, take a picture of yourself, posting it to the door,
mhm.
have a process server fill out an affidavit of service that it was
Yeah,
served on.
you can't overdo it on the proof.
Right.
So, certainly, if you can get the signature, get it if you can. Also, Danielle was asking, does it need to be signed by the landlord? The form we are using from our attorney does not have a signature page. So, would you suggest adding a signature page then?
I'm sorry, can you repeat that?
So Danielle asks for the 231C form if it needs to be signed by the landlord because the form that they're using from their attorney doesn't have a signature
Right. That's why I
page.
was provided the link to the one that the state is providing now. So I
Okay.
would only use that form. It has I'm on that now. I don't know if you all see it, but it does have a signature
Yes,
page at the end, and
I
it
see
does have
it.
a spot at the top where you list the name of the tenant and the landlord. I haven't seen that on other forms. I would
Mhm.
I would use the state form with the signature page 100%.
Perfect. So we will be sending you the slides, which have all of these links embedded. So you can click on the links to get to these forms and make sure that you're using this one, which seems to be the latest that the state has provided. Okay, another question came in as well about how much the landlord can annually raise the rent. Carl is saying this is a huge issue needing clarification.
Okay, so where as if Carl's in a jurisdiction where the where it applies, it can't be raised any more than 5% without 90 days notice. And now it can't be raised at all unless there could be good cause provided. Um,
Yeah, he says he's in Rochester.
okay, so in Rochester, where this just passed, um, so this is all on number 3 on that 231C notice. It's 5% plus the annual percentage change in the consumer price index, uh, you know, really getting into the weeds here, or 10%. So even with a 90-day notice or 30 or 60-day notice, you would have to provide a good cause for raising it. But
Yeah.
so I guess the answer is 10%, and you have to provide a good reason. And the older 2019 Tenant Protection Act is sort of grafted onto that, where if you do want to raise it that much, you have to provide the 30, 60, or 90-day notice.
Yeah. Okay. It's interesting that there's a fill in the blank for the justification for the increase. I suppose cost of goods, inflation. I mean, what
Yeah.
would you put any of those reasons in there?
Yeah, I think those are all good reasons. You want
Yeah.
to chime in here, Robert?
Yes, I think it's similar to there's limits on raising rents in New York statutes now for manufactured home parks. So they would have to justify it by increased property taxes, capital improvements, those types of matters.
Okay. Well, definitely we'll save some of those reasons. I'm sure those are reasons affecting a lot of you on the call. Philip says if the GCEL does not apply in my area because the local government did not opt in, can I just state that in the lease instead of providing a 6-page form when
Oh, no, you have
99%
to
of the
provide the
form
form.
doesn't
Yeah.
apply? But no, you have to no matter what.
Yes, I know it's a
Yes.
pain. It increases
Mm-hmm.
your, certified mail costs, but look, I don't know, whatever town you're in. I mean, we go to some smaller towns outside of Erie County where I think the judges aren't even aware of this, but better safe than sorry. I mean, New York State says you have to provide it, so you have the form there, and if your jurisdiction hasn't opted in, your municipality hasn't opted in, it's easy for you. All you got to do is check those two boxes. So why roll the dice?
Great. Foodhencio just put in the link to this PDF you have pulled up. Thank you for doing that. I really appreciate it. We're going to send you the slides with the links embedded, but this is helpful if anyone of you want to click on that link in the chat. It'll take you straight to the form if you need it right away. Lots of questions about when the CGEL does apply and when it does not. But I do want to move on to just a couple of other topics. Maybe we can revisit some of those specific examples. The first one here from Frederick was how long do you have to wait to send the 14-day notice after the 5-day notice? And what happens if the tenant doesn't accept the certified mail?
So usually what we do is we just wait to the 6th of the month and send them out contemporaneously. Is I've never received any pushback on that. I mean, it's just a requirement that the 5-day notice is sent certified mail. I don't think there's any requirement that it needs to be received prior to the 14-day notice. Just as long as, because we are providing proof of mailing, showing that it was sent on the 6th of the month and no sooner, and that on the affidavit of service for the 14-day notice, that doesn't predate the outgoing postmark on the 5-day notice. If a tenant doesn't accept it, that's fine in either case. So if they don't accept the 5-day uh, delinquency letter, just make sure you keep the receipt from the certified mailing. That's why it's important that it's done certified, so that you have a paper trail showing you did your due diligence. You sent it out. The tenant didn't accept it, and then I just put a copy of that certified receipt along with the 5-day letter. Another thing I've been doing, because I've been getting pushback from tenants' attorneys saying, "Well, how do I know that that receipt matches that 5-day letter?" Before you send the 5-day letter out, write the certified receipt confirmation number at the top of the letter to show that it matches up.
Mm. Okay, great. Midge asking here about giving a 90-day notice to vacate. So if the tenant doesn't pay any rent from that moment on after you give the notice,
No.
and then they offer a small partial payment, how does that affect the eviction process after that 90-day period if they haven't still paid up?
So we do this all of the time, especially where there's these long periods, 90 days before you can file a petition, where maybe the tenant had been paying rent up to that point, but you just want to get rid of them. As soon as you serve them with that 90-day notice, then they stop paying rent. Now they are still responsible for the rent through the period up until the point that their tenancy was terminated. So, say we served them today and we 90 days notice, we'd have to give them until the end of April. And so, February 5th comes along, they didn't pay the rent, they were still responsible for that rent. You just can't take any rent after April. So if they attempted to pay, by all means take it. Just don't take any money for after that. If you terminate their tenancy as of April 30th, don't take any money for May, because that will undo all the work that's been done.
I
Now,
see.
if you're in a situation where the tenant stops paying as soon as they're hit with that notice, well, then serve them with a 14-day notice for non-payment. You get it before the court a lot faster. Of
Hmm.
course, if they do then pay that money, then you can't move forward with it, but at least you have your rent.
Okay. Yeah, and I think Frederick asking, can the landlord refuse to accept partial payments after the notice goes out, um, but before the 90 days is up?
Yeah, so I think it's up to the landlord. I don't think there's any good reason to refuse it because you're just turning away money that
Yeah,
you're entitled to.
right.
I think the theory behind refusing rent. I mean, you can if they're not making full payment, you can't refuse it until they have the full amount. Right. I think the theory behind that with a lot of landlords is well, if I don't take the money, they're going to go spend it on something else, and by the
Hmm.
time it comes time for eviction, if it's a non-payment eviction, and I'm talking about a non-payment eviction here, because you can cure a non-payment eviction by tendering the full amount due. So if you've been accepting partial payments the whole time. Once it comes time to the eviction, it's become much easier for the tenant to cure the deficiency, to pay all the arrears. Now, if you're refusing partial payments that whole time, then the tenant's going to have to come up with the full amount, whereas they may have spent it elsewhere. I mean, I think you should just take the money while you got it, because even if you do, have an eviction granted and a money judgment, the chances of collecting any of that money it's so slim. So while there's
Yes.
money coming in, yeah.
Take it, guys.
Yeah.
Aaron Barnes says if we fail to provide the 231C form to a new tenant recently in a jurisdiction where the GCEL law has not been enacted, can we just email the tenant the form or does it need to be sent by certified mail?
Yeah, I mean, I think emailing is a really good way to show that it was provided. But I think if you can have them sign some sort of acknowledgement or even just reply received, um, I, I think that would be sufficient. Again, nobody's seen how this is going to play out where someone's brought an eviction for very good reason, but didn't provide a tenant the 231C notice. So, what sort of proof the court is going to require that, it was provided with the lease, who knows? Again, it's going to depend on jurisdiction. But I think if you email the tenant replies received, that should be good enough. You think.
Yes.
I can't say anything with any certainty as far as this matter goes.
Yeah, I suppose you just want to be safe and maybe just be a little extra until we know
Yeah.
for sure. I mean, it's inconvenient, of course, but it certainly wouldn't hurt. So, Crystal asking something similar. What about verification of receipt via digital signature, which also is timestamped? That goes for all applicable new writers or a 5-day letter.
Well, I wouldn't say the 5-day letter because I think the statute is clear that the 5-day letter needs to be sent certified.
Mhm.
But as far as providing a 231C notice to someone who has a lease that you didn't initially provide it to, I think attaching it as an addendum sent via email and e-signed, you would hope that that would be good enough.
Okay. Ash says, thank you for answering. Okay. So I want to go back to some of these exemptions. We have lots of case studies here to go off of.
Right. I
Um,
saw a lot of those coming in, and if I could just,
yeah,
make a sort of blanket statement about
sure.
those is I saw somebody, I got 50% in an LLC, or, I have multiple LLCs that own, different properties, but no more, own more than 10.
Mhm.
I mean, I think it's going to depend on how case law defines the very vague terminology in this exception. So, is a landlord the LLC or is the landlord the person who owns the LLC? Um,
Mm, yeah.
I don't know if there is a definite answer to that as far as applies to this. Bob, I just saw you pop up, so do you have
Well,
any?
yeah, it would be if the LLC is the owner of title of the property, which is what we recommend. If you are going to form an LLC, you should have the LLC is the owner of the property and use the LLC name for everything to protect yourself from personal liability, the leases and so forth. So it doesn't matter who the members of the LLC are. They will look to the LLC. The LLC is a separate entity from the member owners. So it would be according to number of units that that particular LLC has title to.
Hmm.
So one person could have multiple LLCs, different LLCs. well over 10, and as long as they were all under a different LLC, they would be considered a small landlord, provided that they, in most jurisdictions, only had one property per LLC.
Hmm. Yeah, it's interesting that the law doesn't specify LLC. I know, just speaking from California, that it does. And you're right, I don't see it anywhere on here specifically that it mentions that. So, huh. Okay. Interesting. We'll have to see how that plays out as well. Maybe we might see that some people try to kind of pretend like they're not a small landlord or that they are a small landlord and they
Yeah.
catch on. So I think the intent is really for it to be like an individual who doesn't, I guess, have involvement in 10 units or more,
Right. Yeah,
is a
that
small
seems to be the
landlord.
intent.
But
Yeah. But there does
yeah,
definitely seem to be a loophole, especially where, if you're own more than one unit, you're a large landlord anywhere outside of New York City. You can
yeah.
LLC for all your different properties. I don't know
Hmm.
how practical that is, but
Yeah, interesting. Okay, yeah, another one that came in was about rent stabilized. So is a lease exempt from the GCEL if the building is rent stabilized?
yes, yeah, there's a box for
Right.
that.
Awesome. Okay, that's usually the case for rent stabilized. Um, Another one came in a little different. Can you discuss what is a certificate of no harassment and is it important? Have you heard of that?
That's new to me. Have you
No.
heard of that?
Well,
No,
I haven't.
I am not.
Okay. Well, we could look into it and maybe get back to you on that and see if it's something that applies. Another one about the CGEL applying if the super lives in a 3+ or 60+ unit building. I don't know that it matters if they live there or not, in the building.
So yeah, one of the exceptions is for employee occupied units. So I believe that it would not apply to the
Mm.
60 other people living there, but the employee of the owner, wouldn't apply to that particular unit where he lives. But it's not going to cause the entire 60 plus unit building. Not all the units are going to be accepted, but the one where the employee lives would be. Is my understanding. If I'm understanding the question correctly.
Yeah, I think that makes sense. Another question came from Joseph. Can you remove staff from a unit and pay for 1 month's storage to be compliant with the eviction laws?
Yeah, well, so I
Hmm.
guess that's a couple parts there. I guess if it's if it's occupied by staff, again, they're going to be the exceptions going to apply. The landlord can remove them. Um, and before removing, again, that I think he's talking about that 30-day of storing property. So I mean, they would have to be, legally removed via eviction, and then from the day that they're kicked out, or from the day that they willingly vacate, you have to uh, keep the property, and that could be stored off-site. So it doesn't have to be kept in the unit. If you have somewhere to store it because you want to re-rent the apartment, you can store it. Just don't destroy it or throw anything out. I usually say if you're not ready to rent it right away and you can just keep it in the unit, just keep it there because then they're just going to have more to go off of saying, oh, you went in there and moved the stuff and now this is moving and now this is missing. So if you're going to move the property off site to store it, just document what's there prior to moving it.
Great. Okay. So I think those were the questions that came in so far. But Bob, you wanted to go over a couple of lease writers that were also important to have on the lease here. Um,
Yes, how much time do you have? And I mean, we could do this as
yeah.
a separate presentation if you'd like to do that.
Certainly I think maybe we could do a little brief overview if you have time to stay a little longer. Um, and I
Yeah,
also
sure. I can
have,
do a
yeah,
quick overview, and if people are interested in further details, we can come back.
yeah, let's do
If
that.
I can share my screen.
Hmm.
Anyway, the certification of no non-harassment, you can get information on that on the New York City housing website. It's required. There's all sorts of different requirements if you want to demo a building or get a change in use. You have to provide a certification of
Yes, and I,
non-harassment.
I I just threw up poll question for everyone too. I forgot about this one. If you want a free renter's insurance guide and addendum, I have one for you. This is something that we didn't talk about today explicitly, but it is very important. I'm sure Justin and Robert, you'll agree to have renter's insurance, to have your renters get renter's insurance. And so we have a quick guide with an addendum for you all to check that out and potentially refer your tenants to get it. We have a special link with Liberty Mutual to do that. So you can't necessarily force them to do Liberty Mutual, but you can at least provide them an option that's pretty easy and affordable. So if you say yes, I will go ahead and email that to you after this webinar. So it looks like, Bob, we have your screen share. Let's go into full screen. And also, we are recording this, guys. So if you have to head out for some reason, you just let me know, and I will go ahead and send you the recording tomorrow. All right. I'll hand it off to you.
Let's see, I think I actually have, I need to share, well, I guess I can use this one. So there's, in addition to the good cause eviction lease writer, there's 12 other lease writers that we recommend. There's further details on our website, wny-lawyers.com, and this can make this PowerPoint available also. That some of these lease writers are required, some are recommended. There's the bed bug addendum, which is recommended. In New York City, there's a required disclosure of infestation history. And with a bed bug addendum, you want the tenant to affirm that they've inspected their property and that it's free of bed bugs, that they will regularly inspect the property for bed bugs and report it to the landlord. If there are bed bugs, allow the landlord access to the apartment to remove it, and cooperate with the landlord and the landlord's pest removal people, and have certain prohibitions, such as not bringing in used furniture. Used furniture often contains bed bugs. And renter's insurance, which was just mentioned, can be very helpful in that respect regarding bed bugs. And if they do have bed bugs, that it's considered a lease violation, and that they would indemnify the landlord for any costs in removing the bed bugs. And as I said, in New York City, there's a disclosure requirement if there's been prior infestation.
So Bob, if you need to go back, you can hit the arrow on the bottom left corner,
Okay,
or this works too.
okay. Bottom left-hand corner?
Yeah,
Or
in
go
the
forward and
actual
go.
slide.
Okay.
There we
Oh,
go.
another writer that we recommend is a confession of judgment affidavit. It's authorized by New York CPLR 3218. It authorizes the landlord to enter a judgment for a sum due or to become due. It has to be in a court in the county where the tenant resides. It must state that it will be that the current consumer debt interest rate for judgments is 2%, state that that applies. And you have to enter judgment in the state Supreme Court within 3 years. It can't be entered after death. And it can be entered just like any other judgment with wage garnishments. If there are joint tenants on a lease, you can only go against the one who signs the confession of judgment. So this confession of judgment would authorize you to obtain a judgment against a tenant without having to go to court. So, the New York courts have been very strict about whether a tenant is liable for drug dealing on his premises. Where some of them saying that if the tenant didn't have knowledge of the drug dealing, the tenant couldn't be evicted. So the U.S. Supreme Court, as part of the 1988 Drug Abuse Act, upheld the rights of landlords or others to evict, even if the tenant was not involved. So we do recommend, there's something we recommend, crime-free, drug-free rider. It's used in all public housing projects. It states that any household member or guest or other person under tenant's control engaged in violent or drug-related criminal activity, regardless of the tenant's knowledge, on or near the premises, be grounds to evict the tenant. So it's part of the Zero Tolerance Drug Abuse Act. And we've been successful in evicting tenants, even Section 8 tenants, based on this crime-free, drug-free rider. This is required a flood history disclosure. It was effective June 21st of 2023. And this is due to unprecedented rainfall and disastrous flooding, which is even becoming more of a problem recently. Every residential lease must disclose any prior flood damage. Lease must also disclose whether the property is within a FEMA designated floodplain or the 100-year or 500-year floodplain. Unlike the law concerning property sales, the landlord is required to determine this themselves. For most locations, you can obtain the information online in the FEMA Flood Map Service Center by entering the address and clicking on Dynamic Map. Residential leases must, and this is required, must also provide notice that flood insurance is available to tenants through FEMA's National Flood Insurance Program. Lead-based paint hazard disclosure. This is required by federal law. Poisoning of children from lead paint and aging rental housing is an ongoing national public crisis. It's a particular concern in New York State, especially in Buffalo and the surrounding area. There was a local landlord and a Buffalo landlord who was sued by a New York State Attorney General, who had to pay $5.1 million in restitution and penalties for exposing children to lead paint. And this applies to pre-1978 housing unless you've gotten a certification that your property is lead-free. So you're required to provide a lead-based paint disclosure and indicating whether or not you have any records of that. And the pamphlet protect your family from lead in your home for all tenants in pre-1978 housing. And you have to be especially concerned about this because your liability insurance might not cover environmental hazards if you're sued for especially children that have been affected, physically affected from lead paint. The move-in, move-out checklist. I've been recommending this for decades, but it's especially necessary under the Tenant Protection Act of 2019, as Justin mentioned. If you are going to deduct any damages from your leases, you have the burden of proof. So under the Tenant Protection Act of 2019, landlords must offer tenants a move-in inspection before they take occupancy of the apartment. If any repairs are needed, the landlord must prepare a written agreement. And then, as Justin mentioned, move-out inspections. Landlords must, on 48 hours notice, notify the tenants of their right 7 to 14 days before the end of the lease term to do a move-out inspection. And you're required to provide an itemization of what will be deducted from the security deposit and give the tenant an opportunity to correct those defects or damages. If landlords should fail to do this, can be sued for actual damages plus punitive damages of 2 times the security deposit. So in addition to that, you have to return the security deposit within 14 days of when they vacate the apartment, or notify them what's being deducted. If you fail to notify them within 14 days, you have to return the security deposit regardless of what the damages were. So you have to keep track of these 14 days. So landlords are required to keep records of smoke detectors. That's the best way to keep the records of when a tenant moves out, moves in and moves out, that the smoke detectors are operating, to meet the requirement to protect carbon monoxide detectors. And they also recommend photographs or videos of the apartment before the tenant moves in, because you have the burden of proof to prove that the damages were caused by the tenant. Personal guarantees are recommended. You don't need to list the guarantor as a tenant, but someone that doesn't meet the qualifications, if they don't have the necessary income, regardless of where the source is. If you're getting a personal guarantee, for instance, from a parent, have them sign a personal guarantee. It should state that it won't be affected by any lease changes, so that the personal guarantee continues on regardless of how the lease is changing. That you're not required to give the guarantor notice of default by the tenant, but you probably should, because they'll probably make it good. And you can back up the personal guarantee by having the guarantor sign a confession of judgment. If you're going to allow pets, have a pet registration form describing the pet, the pet's license number, when the license expires, the vet's name, address, and telephone number. If they've been properly inoculated, for instance, for rabies, that they're going to keep the flea treatments up if necessary, and alternate care in emergencies in case the tenant goes missing or is hospitalized, so you know who to contact so that the pet is not neglected. And there again, you may want to definitely require renter's insurance. You have increased liability from, for instance, from dog bites. There'd be additional protection. We have a special service animal emotional support rider. These are the, if you're going to allow a service animal or emotional support animal as an accommodation for someone's disability, we don't have time to go into great detail about this, but these are the common mistakes that we find landlords making. Not knowing what an emotional support animal is, not knowing what laws apply to emotional support animals, not knowing the difference between emotional support animals, service animals, and therapy animals. Service animals have specific training for a specific person. Therapy animals are trained to provide therapy in various situations in general, such as a part of therapy for people, emotional therapy, people that are victims testifying in court. Emotional support animals are only for people's having a certification from a medical or social worker or therapist certifying that in order for them to enjoy the apartment or unit, they need this emotional support animal. We don't have time to get into this. I do have material in the AAOA magazine with further details about this, and on our website. Asking too many questions, another mistake, requiring that the tenant provide only a doctor's letter, limiting to only a doctor's letter, asking for the tenant's medical records or confidential healthcare information, not requiring tenants to sign a lease rider. That's why you can require them to sign a lease rider. You can't restrict it to a specific breed or charge additional security deposits. Now, a lot of this has to do with reasonableness. The tenant needs to certify that the animal is not a threat, it will not cause damage. You can provide that if they violate this tenant service ESA rider, that they'll be given 10-day notice to correct it, or they can be evicted. The tenant's obligated to clean up after their pet. um, obligated to, if it's a dog, to walk it on a leash or keep it restrained at all times. If the animal's a nuisance, that definitely gives you, as a nuisance to other tenants or damaging the property, that definitely gives you grounds to evict the tenant for violating the service animal ESA lease addendum. Smoking policy. Certain cities and counties require you to have your smoking policy. I still recommend that you do a smoking policy. City of Buffalo requires it. Rockland County requires it. Also, the New York State Clean Air Act prohibits smoking in places of employment. So if you have employees, they don't need to put up with smoke, tenant smoke. It has to be a smoke-free workplace, wherever you may have outside vendors working or your employers working. New York City Smoke-Free Air Act of 2002 applies to 10 or more units. You can face all sorts of legal liability for smoke. Breach of the warranty of habitability. The property could be rendered uninhabitable by other tenants smoking. Could cause fires. There's various grounds of legal liability. You spell out in your smoking policy where smoking is prohibited. Is it prohibited everywhere? It's prohibited in community, common areas. You can prohibit it within 20 feet of the building. Include electronic cigarettes and marijuana in your policy, and what the complaint procedure if a tenant has complaints about smoke. Sprinkler disclosure law was required since December 3rd, 2014. Sprinklers involve heat from fire automatically causing water to be discharged. You have to disclose whether there are a sprinkler system and the date that it was last inspected and maintained. Another requirement as of March 2nd, 2021 under New York human rights law, and there's a specific state required disclosure form to all tenants, their right to request reasonable modifications and accommodations if they have a disability within 30 days of the beginning of their tenancy. So tenants with a physical, mental, or medical impairment can request changes to the interior to make it accessible. They must pay for these modifications and can be required to restore the unit to its original condition when they move out. Changes to rules, policies, practices, and services, such as a no pet provision. They can ask for a modification of the no pet provision because of the disability, that they need an emotional support animal or a service animal. Changes to common areas of the building so that tenants have an equal opportunity to use the building. Landlords are required to pay for reasonable modifications to common use areas. So it's a reasonable accommodation. It's going to depend on the particular circumstances. And we've got examples of reasonable modifications and accommodations that may be requested. These are all listed on the PowerPoint. So those are all the riders. Additional information on our website. I can make this PowerPoint available also. And I don't know if we have any questions, if we have time for any questions, but we appreciate your time this afternoon.
Thank you so much for going over that. I know it's definitely way over on time, but that as well, because I know some of these are just so important to have, and your lease may not have them as we're going into a new year. You're updating your leases. Definitely think these over. I have some questions that are coming in, lots of thank yous. Can I get the recording, the PDF, the links? Yes, we're going to be sending all of that to you. And I'm also going to provide you with the attorney's contact information and also their website, of course, so that we are able to make sure you don't miss anything, because we covered so much. So I appreciate all of you who have stuck around to the very end. You all are really learning so much, I hope, from this. And we hope to see you again soon. It will have probably another update at some point. So I hope that you'll stick around and join us for that. And also, just to finish here, next week I am doing a webinar that I'll be hosting specifically about tenant screening. And so, obviously, New York has its own tenant screening laws. I'm familiar with some of the newer ones that have come out. We'll be covering a little bit about some of those specifics, but I'll be going over just a general overview of best practices in fair housing as well in that process. So I hope that you'll join next week. There will be an invite in that follow-up email. I'm going to see if I can send it out today, but it might be tomorrow that I'm going to send that email with the recording and all the things. But I'll do my best to get it out to you all as soon as I can. Bob, thank you so much for sticking around, and Justin as well. You all are such a great resource for our members. We really appreciate you.
I'm glad to do it, and thank you for hosting this.
Thank you. All right, everyone. Have a wonderful day. We'll see you next time.
You too.
Bye.